Hello and welcome to Courts Today by LiveLaw. Let us get to today's top legal headlines. The Bombay High Court has directed the Mumbai police not to arrest Kunal Kamra in the FIR over alleged remarks on Eknath Shinde, but the probe may continue. A Kerala Bar Association has scripted history by electing only women as office bearers. The Supreme Court has slammed Congress leader Rahul Gandhi for comments against Savarkar and has stayed the defamation case against him. The Supreme Court has dismissed Punjab government's plea against bail of Akali leader Bikram Singh Majithia in the NDPS case. The Supreme Court has held that invalidated soldier is presumed to be disabled due to military service and is entitled to disability pension. And the Patna High Court has refused to quash an FIR against a suspended judge in a dowry death case and has ordered for a CBI probe. I am Urvashi Chauhan with your daily roundup of legal updates from across the country. For a detailed reading, you can always visit www.livelaw.in. Please make sure to watch this video till the end and do not forget to like, share and subscribe to our channel. But before I get to the detailed news, here is an exciting opportunity for judiciary aspirants. LiveLaw Academy, LiveLaw's judiciary coaching initiative, has opened registrations for its May batch. You get to choose from two tailored courses. First is JESEP 2.0, a comprehensive 18-month online program covering everything you need to crack the judiciary exam, taught by an expert panel including retired judges. And second is JESEP Lite, a flexible weekday-only program for those who prefer a structured yet lighter approach. Sign up today and get exclusive 25% early bird discount, plus enjoy free LiveLaw subscriptions, case compilations, and much more. Do not miss this opportunity. Enroll today at www.livelawacademy.com. The Bombay High Court has today directed the Mumbai police not to arrest comedian Kunal Kamra in the FIR filed against him for allegedly calling Maharashtra Deputy Chief Minister Eknath Shinde a Gaddar in a satirical video. A division bench of Justices Sarang Kotwal and Sriram Modak also instructed the police to visit Kamra's residence near Villupuram in Tamil Nadu with the help of local authorities if they want to record his statement. The court further added that if a charge sheet is filed during the pendency of Kamra's plea, the trial court should not take cognizance of it. Senior advocate Navroz Sarvai, appearing for Kamra, argued that the video was political satire protected under Article 19(1)(a) of the Constitution. He claimed the FIR was a targeted move to intimidate artists and crush dissent, especially as the alleged defamed person Eknath Shinde had not filed the complaint himself. Sarvai also highlighted the irony of political leaders using the term traitor freely while a stand-up comedian is being prosecuted for the same. He said that the show was a commentary on contemporary politics and not meant to incite fear or unrest. But on the other hand, Chief Public Prosecutor Hiten Venagaonkar argued that Kamra's comments went beyond satire and amounted to malicious targeting and so did not fall under the protected speech. He stated that the Article 21, that is the right to dignity, also extends to public figures and satire cannot be used as a shield to tarnish reputations. Kamra, who resides in Tamil Nadu, had earlier been granted interim protection from arrest. The FIR was registered by Shiv Sena MLA Muraji Patel and later transferred to Khar police station in Mumbai. Although Kamra did not name Shinde directly, Shiv Sena workers alleged that the Gaddar reference was aimed at him. They later vandalized the studio where Kamra had performed, resulting in multiple arrests. The High Court's order today offers Kamra a crucial reprieve while also raising broader questions on the boundaries of free speech and satire. In a significant milestone for gender representation in the legal profession, the Pala Bar Association in Kerala has elected an all-women panel to its executive committee. All 15 positions were won by women lawyers, a historic first for the association. This development comes at a time when the demand for greater women's representation in bar associations is gaining momentum across the country. Last year, if you recall, the Supreme Court mandated that at least 1/3 of the posts in Supreme Court Bar Association be reserved for women. The direction has since been extended to other associations, including those of the Delhi High Court and Karnataka. But the Pala Bar Association's election goes a step further, choosing an entirely women-led leadership well beyond the mandatory 1/3 reservation. This sets a new precedent for gender-inclusive leadership in India's legal institutions. Do visit LiveLaw.in to know in detail about the elected office bearers. In an important update, the Supreme Court today voiced its disapproval of Rahul Gandhi's controversial comments about freedom fighter V.D. Savarkar. Although the court stayed the defamation proceedings against him in a Lucknow court, it warned Gandhi that any similar statements in the future would result in a suo motu action. The remarks in question were made during a press conference where Gandhi called Savarkar a servant of the British and claimed that he took a pension from them. Justice Dipankar Datta Kamra pointed out that even Mahatma Gandhi had addressed the British Viceroy as your faithful servant in letters and criticized Gandhi for making such statements without understanding India's history. The court made it clear that Gandhi must refrain from making irresponsible statements about freedom fighters going forward. If any similar remarks are made, the court will take action without waiting for any formal complaints. The complaint filed here against Gandhi accused him of spreading hate by calling Savarkar a British agent. Gandhi had appealed to the Supreme Court after the Allahabad High Court refused him relief earlier this month. In another update, the Supreme Court has today dismissed Punjab government's petition challenging the bail granted to Shiromani Akali Dal leader Bikram Singh Majithia in a drug-related case. A bench of Justices J.K. Maheshwari and Arvind Kumar refused to interfere with the Punjab and Haryana High Court's order granting regular bail to Majithia. The bench further directed that neither the Special Investigation Team nor Majithia should make any statements to the media about the ongoing investigation. The court was hearing an appeal filed by the Punjab Police which alleged that Majithia was attempting to influence witnesses and publicly targeting members of the SIT through press conferences and social media posts. The State's Counsel pointed to an incident where Majithia allegedly leaked details of impending search operations on social media, compromising the element of surprise. The counsel argued that Majithia's actions were hampering the investigation. However, senior advocate Dr. S. Muralidhar, representing Majithia, refuted the allegations and countered that it was actually the investigation officers who were holding press conferences after every interrogation. Taking note of these submissions, the Supreme Court warned both sides against making public comments on the case and asked Majithia to submit an affidavit agreeing to this condition within 1 week. The court has also directed that Majithia must not influence witnesses or interfere with the trial. If there is any violation, the prosecution may seek further directions. Similarly, police officers must obtain the court's permission before making public statements about the case. And now let me tell you, the top court has ordered the Indian Army to grant 50% disability pension to a former soldier who was discharged from service 36 years ago. The court said that a soldier who is found medically fit at the time of joining is presumed to have developed any later disability due to military service unless the army can prove otherwise. The appellant here, who had joined the army in the year 1985, was invalidated in 1989 on account of the disease generalized tonic-clonic seizure old 345V67, assessed at less than 20% on the recommendations of the invalidating medical board. The appellant claimed that he was hale and hearty at the time of joining the army and the disease was contracted due to his posting at high altitude Siachen Glacier from May to September 1988. Let me tell you, as per Regulation 173 of the Pension Regulations for the Army 1961, disability pension is given only when the disability is 20% or more and linked to military service. But the court said if a soldier is found medically fit at the time of joining, any disease or disability that appears later is presumed to be due to military service unless the army can prove otherwise. The court also disagreed with the Armed Forces Tribunal, which denied a disability pension to the appellant on the ground that his disability was less than 20%. The court said that any disability which leads to discharge should be assumed to be above 20% and attract at least 50% pension. The court has also reminded the army that the burden of proof lies on them and not the soldier. It has therefore directed the army to pay the pension from January 1996 with 6% interest and complete all payments within 3 months. And lastly, the Patna High Court has delivered a significant ruling in a case involving a suspended judicial officer, Pratik Shail, in connection with the alleged dowry death of his wife. The court declined to quash the criminal case filed against him, noting that there were prima facie materials pointing to harassment and cruelty related to dowry demands. The case here revolves around an FIR filed by father of Shail's wife, alleging that his daughter had been subjected to both mental and physical abuse due to the demands for dowry, leading to her death just 15 months after the marriage. The father claimed that the petitioner had made an initial demand for 20 lakh in dowry, part of which had been fulfilled in the form of a car and gold ornaments. However, he failed to provide proper medical care even when his wife exhibited signs of serious illness, including amenorrhea and intermittent vomiting, which are indicative of abdominal tuberculosis. The court pointed out that had the wife been treated properly earlier, her death might have been prevented, suggesting negligence on the part of the petitioner. The court also noted that medical documents revealed contradictions regarding the timings of certain medical tests and treatments and emphasized that the police had failed to register a case under IPC and Dowry Prohibition Act despite serious allegations. Given the sensitive and complex nature of the case, especially due to the petitioner's position as a judicial officer, the court directed that the investigation be transferred to CBI. The court raised concerns that local police under under the influence of petitioner might not conduct a fair investigation, thus warranting the involvement of an independent agency. In its ruling, the court also highlighted that the FIR could not be quashed as there was sufficient evidence to proceed with the case. The court has directed the petitioner to surrender to the authorities within 3 days, failing which a non-bailable warrant would be issued against him. Furthermore, the court has allowed the CBI to include additional charges of Section 304A, causing death by negligence, and Section 304 Part 2, that is culpable homicide not amounting to murder, along with Section 498A and the Dowry Prohibition Act.